Mr. President.
Senator from Iowa.
Mr. President, I have 10 unanimous consent requests for committees to meet during today's session of the Senate. They have the approval of the majority and minority leaders. I ask unanimous consent that these requests be agreed to and that these requests be printed in the record.
Is there objection? Without objection, so ordered.
Mr. President, recently the National Labor Relations Board General Counsel issued a complaint against the Boeing Company, alleging that the company had violated the National Labor Relations Act. Well, this routine administrative procedure has set off what I call a melodramatic outcry from Boeing, the business community, the editorial writers of the Wall Street Journal, the National Chamber of Commerce, and, of course, our friends on the Republican side of the aisle. A headline in the Wall Street Journal's editorial page called it, quote, "The Death of Right to Work," end quote. South Carolina Governor Nikki Haley declared that it was, quote, "government-dictated economic larceny," end quote. At a press conference held at the Chamber of Commerce yesterday morning, Senator DeMint from South Carolina referred to it as thuggery. The senior senator from Utah warned that foot soldiers of a vast and permanent bureaucracy were trying to implement a, quote, "leftist agenda." You would think that this one decision by an administrative arm of an independent agency was surely going to bring about the death of capitalism, as in the world today. I mean, this has taken on incredible proportions in terms of the outcry and the mischaracterization of what's happened. So instead of talking about how we get Americans working again, get the middle class on its feet, our colleagues on the other side of the aisle are taking their time on the Senate floor and in press conferences downtown, attacking the handling of a routine unfair labor practice charge. Now, again, I don't think it's really worth the time of the Senate to debate this. However, because of this huge outcry and the fact that the Wall Street Journal has chosen to editorialize on this, and because of the disturbing misinformation that has distorted public discussion of this case, I'm going to take some time on the Senate floor to try to, as they say, set the record straight. I've said before that this Boeing case is a classic example of the old saying that a lie gets halfway around the world before the truth laces up its boots. Well, in this case, I would say Senate misinformation travels even faster than that. So it is time to set the record straight. Here are the facts in the case. It's undisputed. Boeing recently decided to locate a production facility for the new Dreamliner planes in South Carolina. They decided to do that. Many statements were made by executives of Boeing, publicly stated that the decision to move there was based in whole or in large part on the fact that there had been work stoppages, strikes, in the last few years at the Boeing plant in Everett, Washington. The NLRB's complaint alleges that this decision was unlawful retaliation against the Boeing workers in Washington State. Now, this has been put into a political context, but let's again be clear about how this happens. The National Labor Relations Board is an independent agency set up under the Wagner Act 75 years ago. There's like two branches of the NLRB. One is the board, the NLRB, the National Board. It is a 5-member board appointed by the President with the advice and the consent of the Senate. On the other hand, there is the career service people, the civil servants, who are not appointed, they're non-political, They carry out the day-to-day functions of the National Labor Relations Act. If I might say, it's just similar to, let's say, the Food and Drug Administration. The Food and Drug Administration has an administrator appointed by the President, vice and consent of the Senate, as does a lot of other independent agencies. But then there is a civil service side of it that is professional. There are professional people not appointed by the President. They have career civil service status. The General Counsel of the National Labor Relations Board is in that area, in the area of the career civil service. That person is in that career civil service. The acting attorney, the acting general counsel now has been a civil servant for 30 years. 30 years. So what happens is that a business or a union, well, it doesn't have to be them, it can be anybody, can file a complaint with the NLRB alleging that certain actions were in violation of the National Labor Relations Act. One of the provisions of the National Labor Relations Act says that it is unlawful for a company to retaliate against workers for a protected activity conducted by those workers. Protected activity. One of the protected activities under the National Labor Relations Act is, of course, the right to organize, the right to join a union, and, of course, under the Taft-Hartley bill some years later, the right not to join a union if you don't want to, so-called right-to-work states. So the protected activity in this case was the right to strike. The National Labor Relations Act protects that activity. Organized workers in a union have the right to strike. It's a protected activity. A company cannot retaliate against workers for exercising that right. So if the Boeing company did in fact move a production line to another state in retaliation for the workers that exercise their right to strike in Washington, that would be illegal for Boeing to do that, unlawful. Now, I said if because I am not here today taking a side in the case. I'm not certain where the truth lies. This is for the trier of fact and the trier of law. So when a case comes to the National Labor Relations Board, a complaint like this, they investigate it. Well, the National Labor Relations Board investigated under the General Counsel's office the civil service part of this, did an investigation. They took affidavits, they talked with people to find out whether or not there was any cause to move forward. Now, again, whether it's right or wrong, I don't know, but this independent board decided that there was enough evidence for them to warrant taking this case to an administrative law judge. Now, that's the process. So Boeing then can make its case before the administrative law judge. The General Counsel's office can make its case. The administrative law judge then makes a decision. As I understand it, the administrative law judge can uphold the General Counsel's provision or finding. It can uphold or cannot uphold it, or it can modify it. After that's done, either side can appeal it. And that appeal then goes from the civil service part, goes over to the National Labor Relations Board. After the board then reviews it, they make a decision. They either uphold what the administrative law judge said, or they don't uphold it. From there, either side can appeal to the Circuit Court of Appeals. And from the Circuit Court of Appeals, they can appeal to the Supreme Court of the United States. That's the process. That process has been followed now for 75 years. We follow similar processes in other independent agencies of the federal government. As I mentioned, the Federal Food and Drug Administration, the Federal Trade Commission, a lot of other independent boards and agencies have that same process. So what's happened now is that many of our friends on the Republican side and in the business community, they have now taken up this hue and cry that this process should be interfered with, that this process should somehow be stopped politically. Well, I don't think it's our right, our job here to interfere in something like that politically. Now, if my friends on the Republican side do not like the provision of the National Labor Relations Act, which says it's illegal to take retaliation against workers for protected activity, if my friends on the Republican side want to change that law, offer a bill, offer an amendment. That law can be changed, you know, with both bodies, with the House and the Senate and the President signing it, change it. But it is wrong for, I believe, elected officials like me or anyone else to interfere in that process and to cast it as a political decision. But that's what's being done by so many Republican senators and people in the business community. They've alleged that President Obama was behind this, that somehow because he's appointed a couple of members of the National Labor Relations Board that he is behind this. President Obama had nothing to do with this. This was a complaint filed by the Machinists Union, the International Association of Machinists, with the NLRB. President Obama has nothing to do with this whatsoever. And he shouldn't have anything to do with it. But, again, people on the Republican side are alleging, again, misinformation going out, that somehow this is being orchestrated out of the White House. Well, again, the facts. The facts are this was a complaint filed. The NLRB, the National Labor Relations Board, is doing exactly what they've done for the last 75 years. It's going to go before an administrative law judge and then find out how it works its way through the courts at that time. I'd ask my friends on the Republican side that if, in fact, the Boeing Company did, in fact, retaliate against workers because of a protected activity, do my friends on the Republican side say that that should be okay? Is that what they're saying? That a company, that if workers exercise a legal right, that they have a legal protected right, and a company retaliates against those workers in any way, are my Republican friends saying they ought to be able to do that? You can take all kinds of cases. Let's say that a company decides to move a plant from Southern California to, let's just say Fargo, North Dakota. And the reason they stated that they moved it was because there are too many Hispanics working in their plant in Southern California. And they didn't like that, and they wanted to move to Fargo, North Dakota, because there's not that many Hispanics there. Guess what, folks? That's illegal. That's illegal. Do my friends on the Republican side say that they ought to be able to do that in violation of all of our civil rights laws in this country? Of course not. People say, of course they can't make that kind of decision based on that. Can't make a decision to move a plant where there's more men than women because they won't have to hire as many women, or less African Americans so they don't have to hire African Americans. You can carry this on and on. So I hope that what my friends on the Republican side, I hope they're not saying that a company can retaliate and then just walk away without any penalties, without even any recourse by the workers to have their case heard. That's what I'm here defending. I'm defending the rights of the workers in the plant in Everett, Washington, to have their complaint heard. I don't know the facts. I know a little bit of the law, but I don't know the facts. That's for the trier. That's for the administrative law judge and the NLRB and the appeals court and the Supreme Court. That's their jurisdiction. But for us to say it shouldn't even go there, that these workers can't even bring a case. And I might say that there are a lot of cases that are filed with the NLRB that don't go anywhere because the NLRB investigates, they do their due diligence, they find out there's not even enough evidence there to warrant going forward. So all I can assume is that there was enough evidence to warrant going forward. Whether there's enough to actually find that Boeing did retaliate, again, I don't know. That's up to the trier of fact, the administrative law judge. But what I'm hearing from these dramatic outcries that somehow we're destroying right to work, this case has nothing to do with right to work. Nothing, zero, nothing. It has nothing to do with right to work laws. Outcry that somehow this is destroying the essence of a business to be able to decide in its best economic interest where to locate. This case has nothing to do with that. If Boeing wants to open their plant in Timbuktu, they can do that. If they want to open a plant in South Carolina, they can do that. What they can't do is they can't open a plant someplace in retaliation against the workers exercising their legal protected rights. That they can't do. Now, again, this is an evidentiary type hearing, so the evidence will have to come forward as to just what decisions were made, why were they made. Quite frankly, there are executives of Boeing who have publicly stated, that one of the reasons they moved this was because of the work stoppages at the Everett plant. Work stoppages, strikes. Is that enough evidence? I don't know. Maybe it's enough evidence to warrant going forward. Obviously, the General Counsel's office decided that there was. I would also point out, Mr. President, that the General Counsel's office, in cases like this, works long and hard to try to settle the case, to get both sides to settle it. I know the General Counsel's office in this case did try to do that, but they were unsuccessful, and so therefore the case goes forward. And so I wanted to point out again, just to reiterate, Mr. President, this is not about doing away with right-to-work laws. It has nothing to do with that. It has nothing to do about interfering with businesses making their decisions on where to locate their plants or anything like that. It has nothing to do with that. It has nothing to do with destroying capitalism. What it has to do with is whether or not workers have a right. First of all, can they exercise legal protected rights, and then can they make a case to the NLRB that they were retaliated against because they exercised their legal rights? That's what this case is about. That's what this case is about. Now, again, I understand the desire of certain people to raise money for political campaigns. I understand that. And I understand how you exaggerate things a lot of times in direct mail and in the press. And I'm sure that there'll be a lot of businesses gone to say you've got to contribute to this campaign or that campaign to stop to stop President Obama or to stop the National Labor Relations Board from taking your business decision away from you. Well, that's misinformation. I know it can be used probably to raise a lot of campaign money, but it's not right. It's not right to deceive and to misinform the American people about a basic right that protects the middle class and the middle class workers in America. Americans understand fairness, and they resent it when the wealthy and the powerful manipulate the political system to reap huge advantages at the expense of working people. I think I've always been a pretty good friend of the Boeing Company. I've been a big supporter of Boeing and so many things going back my 30 years here in the Congress. It's a great company. They provide a lot of great jobs for American workers. They build great airplanes, better than Airbus, I might say. But it's wrong for them now to come into the political system and try to get the political system to undo a legal administrative procedure that the workers at that Boeing plant have instigated and have asked for the NLRB to investigate and to charge Boeing with retaliation. But what's happening in this case is that the powerful and the big are trying to manipulate the political system. Powerful corporate interests are pressuring members of this body to interfere with an independent agency rather than letting it run its course. We should not tolerate this interference. We should turn our attention to the issues that really matter to American families. How we can create jobs in Washington, yes, in South Carolina, in Iowa, across the country. How we can rebuild the middle class. How we can ensure that working hard and playing by the rules will help you build a better life for your family and your children. Playing by the rules. Well, that's what we did. That's what the workers did. They played by the rules. They exercised their legal rights. And now there's a complaint filed, and I say it's wrong for us to interfere in that. Again, if we don't like the law, if we don't like the administrative procedures that undergird this, it can be changed. It can be changed. But I dare say we've had 75 years of the Wagner Act, of this process, and sometimes, I'll close on this, sometimes businesses file a complaint with the NLRB against a union activity. That's investigated. That goes before administrative law judges, too. So both sides use this. I think it's unbecoming for us now to try to turn this into some kind of a political, almost a political maelstrom, a political tornado, when it shouldn't be that. Let's let the law and let's let the administrative procedures do its job. And then, if corrective action needs to be taken, then it's the purview of Congress to do it at that time, not now. Mr. President, I yield the floor.
Senator from Virginia.
Mr. President, I ask unanimous consent to speak for up to 10 minutes as if in morning business.
Without objection.
Thank you, Mr. President. Mr. President, I would like to express my appreciation to the leadership here in the Senate of both parties for scheduling a vote today on Arenda Wright Allen's confirmation for a seat on the United States District Court in the Eastern District of Virginia. All of us in this body know how important it is to be filling the vacancies on our federal bench, and particularly when we have highly qualified nominees who have no particular issues that need to be discussed in a political sense, and Virginia is no exception in this matter. The sheer volume of our federal court's workloads demands that we appoint dedicated, qualified jurists, and in that regard, Senator Mark Warner and myself were very pleased to have recommended Orinda L. Wright Allen to the President in June of last year for this position on the United States District Court for the Eastern District of Virginia. President Obama nominated Orinda Wright Allen last December. She was renominated this year. She was reported out of the Judiciary Committee without opposition March 10th of this year. And I believe that the President has made an extraordinary choice in nominating Ms. Wright Allen. Whenever a vacancy has occurred on the Virginia federal bench, Senator Warner and I have very carefully conducted thorough and extensive reviews of candidates for the position. This review process includes interviews and recommendations by the bar associations and in-person interviews with many of the candidates. I'm proud to say that the candidate pool from Virginia from which we had to choose on this particular occasion was excellent. It was deep. It included judges, legal scholars, and skilled trial attorneys. And from this very competitive field, Senator Warner and I moved for the nomination of Ms. Wright Allen. She distinguished herself as the premier candidate in a very competitive field for this vacancy. She has displayed during her career the highest degree of integrity, competence, and commitment to the rule of law. She exemplifies the best of the Virginia bar, and in fact, she received the highest ranking from the Virginia State Bar. As one who was privileged to serve as Secretary of the Navy and also as a combat Marine, I personally understand the sacrifices that veterans have made to their country. Ms. Wright Allen is a veteran of the United States Navy. She served for 5 years as an active duty JAG officer. She continued her service as a reservist, a JAG officer, until her retirement from the Navy as a commander in 2005. Her record of military service is excellent. And given the huge military presence in the Eastern District of Virginia, I believe that this military experience will be valuable to her in her capacity as a federal judge. Ms. Wright Allen has dedicated her civilian career to serving her community, first as a federal prosecutor and since 2005 as a federal public defender. Unanimously, prosecutors and defenders who have worked with or have been on the opposing side to Ms. Wright Allen have attested to her talent, her dedication, and above all, her exceptional character. Upon meeting her, it was clear to me that she possesses the correct judicial temperament and dedication to make an excellent judge. I've also had the pleasure of meeting her family and a number of her friends. Her dedication to her family, her church, and her community is clearly evident. Now, I am proud that Virginia has such an exemplary individual to put forward as a federal district court judge nominee, and I urge all of my colleagues to support Ms. Wright Allen today. With that, Mr. President, I yield the floor.
Mr. President.
Senator from Arizona.
Thank you, Mr. President. On behalf of myself and Senators McCain, Sessions, Cornyn, Vitter, Wicker, and Inhofe, and probably others before the end of the day, I'm going to introduce today legislation called the New START Implementation Act, which I would like to describe briefly for a few minutes here. This legislation is nearly identical to a companion bill introduced in the House of Representatives by Mr. Turner, the chairman of the Strategic Forces Subcommittee, the Armed Services Committee. He has been a leader in the House on nuclear and missile defense issues. And I understand that many of the provisions have been included in the chairman's mark of the National Defense Authorization Act in the House, and that the remainder will be introduced as amendments later today at the full committee level. And I specifically want to thank Chairman Turner for his leadership. Nuclear deterrence issues are among the most complicated and technical issues that we in the Congress are confronted with, and he deserves full credit for tackling them with vigor and for mastering them so quickly. Like the House legislation, it's my hope that the Senate bill will be incorporated into the Senate version of the National Defense Act for fiscal year 2012. And let me now explain a little bit of why I think this legislation is necessary at this time. I voted against the New START treaty for reasons that I've made clear previously on the floor. But I recognize that the President's stated commitment to the modernization of our nuclear deterrent is necessary and is important, and that Congress needs to codify the commitments made during the debate on the New START ratification process, as well as the agreements that the President has indicated through his comments and letters to us. This is important for the future, for future Congresses and future presidents, because this process is going to take place over a period of at least 10 to 12 years. Modernization of our nuclear weapons facilities and the strategic delivery systems all will require commitments over this space of another decade or more. Memories fade, people's interpretations may change over time, circumstances change, and what we want to make sure of is that over the time period involved during which this modernization process must occur, that the understandings that were agreed to at the time of the START treaty ratification will be memorialized in statute and complied with by the Congress and by the administration as time goes on. The 5 key features of the legislation are these. First, it would link the funding of the administration's 10-year nuclear modernization program with any U.S. nuclear force reductions during the implementation phase of the treaty. What that means is that as in the later years of the treaty, funding is necessary for the demobilization, dismantling of some of the weapons that are called for to be dismantled under the treaty, but that funding is coordinated with the funding for the modernization program, which is going on at the same time. It urges the President to stand by the timelines that he pledged on warhead modernization in the revised plan that he submitted in November of 2010. This is key to ensuring that Congress will support these modernization efforts that were deemed necessary in conjunction with the New START treaty. The second thing the bill does is to ensure that U.S. nuclear doctrine and targeting guidelines and the New START force levels that former STRATCOM Commander General Kevin Chilton said were exactly what is needed are not arbitrarily cut by the administration that seems eager now to go to even lower levels, perhaps even unilaterally, than were negotiated in the START treaty. The President has indicated his desire for a world without nuclear weapons, has said that he'd like to do new things in the future to reduce the numbers of these weapons, and we simply want to make certain that the guidelines that are militarily necessary reference points for the number of weapons we have, the types we have, how they're deployed, and so on, are not modified in order to be a reason for or an excuse for reducing strategic weapons thereafter. I think this is necessary because the President's National Security Advisor said on March 29th that even as we implement New START, we're making preparations for the next round of nuclear reductions. And in developing options for further reductions, he said we need to consider several factors, such as potential changes in targeting requirements and alert postures that are required for effective deterrence. We were told that the New START force levels were exactly what is needed for deterrence, and yet now the administration may seek to alter deterrence requirements in order to justify further reductions. My view is the administration can't use one set of facts to ratify the treaty and then immediately change those facts in order to suit its global zero agenda. 41 senators made clear in a letter to the President on March 22nd that we expect the administration to consult with Congress before directing any changes to U.S. nuclear weapons doctrine or before proposing further strategic nuclear reductions with Russia. No consultations have occurred to date, and we expect that those consultations would occur before any discussions with Russians take place. Third, the legislation would ensure that the triad of strategic nuclear delivery systems, that is to say the bombers, cruise missiles, ICBMs, and ballistic missile submarines, are modernized and that their reliability is assessed each year. Even today, we're still uncertain about the administration's plans to modernize the ICBM leg, nor do we know if the new bomber will be nuclear certified upon its deployment. For example, according to an April 22nd press account in the Global Security Newswire, The U.S. Air Force cannot say exactly how much it will spend or explore options for modernizing its ICBM fleet, nor where the money will come from." End of quote. Well, obviously, if we are currently planning the modernization of these fleets, but we don't even know where the money is going to come from for the planning, we've got a problem that needs to be resolved now rather than later. And that's what the third requirement of the legislation would require. Fourth, the bill would affirm that the New START treaty contains no limitation on U.S. missile defenses beyond the language in Article 5, Section 3, and that any future agreement with Russia that would attempt to limit U.S. missile defenses can only be done by a treaty requiring the Senate's advice and consent. Now, none of this is different than what we all talked about on a bipartisan basis when the New START treaty was ratified, but we think it's important that these commitments actually be codified to ensure that they're kept. And finally, the bill would counsel against unilateral reductions or withdrawal of U.S. non-strategic nuclear weapons in Europe without the unanimous approval of NATO members. Obviously, in NATO, one state should not be permitted to end NATO's successful Article 5 policy, the policy that an attack on one is attack on the others and will be met with resistance from the other NATO allies. So, Mr. President, in conclusion, I think this bill should enjoy broad congressional support, given the fact that it merely builds on what the Senate and the administration agreed to in the New START resolution of ratification with respect to nuclear modernization and our freedom of action to develop and deploy missile defenses. It ensures that a future Congress and a future President understand and support the current commitment to nuclear modernization and ensures that there will be no further limitations on our missile defense efforts. And finally, it builds in vital checks to permit congressional oversight of impending activities by the administration that portend significant changes to U.S. nuclear doctrine, further strategic nuclear reductions, and potential activities with possibly concessions to Russia with regard to missile defense and tactical nuclear weapons in Europe, all of which might be counter to U.S. security. I would be pleased to add other colleagues as co-sponsors to the legislation. As I said, I intend to actually introduce this toward the end of the day, and I'm sure we will have additional co-sponsors by that time. Mr. President, I note the absence of a quorum.
Clerk will call the roll.
Mr. Akaka. Passed unanimously.